Welcome, dear students. Today I will be dealing one of the most important topics of agriculture. The viewers whosoever are engaged directly or indirectly in agriculture, they must have awareness about it. The topic is the Protection of Plant Varieties and Farmers' Rights Act 2001, which is also known as PPV and FRA 2001. So I will be dealing different terms related to it one by one. So, as introduction, we can say the Protection of Plant Varieties and Farmers' Rights Act 2001 is one of the unique and innovative acts of India. It involves diversified stakeholders ranging from tribals, farmers, research institutions, seed industry, government, legal systems, and so on. They are all involved for its implementation. It requires a massive awareness campaign to be undertaken for creating desired awareness about its provision. As you recall that earlier there was a lot of hue and cry among Indian farmers about implications of WTO, GATT, TRIPS, where there was fear to become dependent on developed countries for the seed and planting materials. You might be recalling those days. The UPAW, you see about the UPAW, the International Union for the Protection of New Varieties and of Plants, has been established by the International Convention for the Protection of New Varieties of Plants. The UPAW Convention was signed in Paris in 1961. The convention entered into force in 1968. It was revised in 1972, 1978, and in 1991. The 1991 Act entered into force on 24th April 1998. The mission UPAW The mission of UPAW is to provide and promote an effective system of plant variety protection with the prime aim of increasing the development of new varieties of plants for benefit of the society. Because of the above said fear and pressure of Indian farmers, the UPAW with its headquarters at Geneva has made provisions to develop sui generis system for all the member countries. What does it mean? That they can make some alterations in these system depending upon the situation of their own countries. So it was given, the provision was given by UPAW to member countries. Now we should know about some important organizations and bodies related to PPV and FR. The first one, GATT. It is General Agreement of Tariff and Trade, which was signed by 23 nations in Geneva on 30th October 1947 and came into force on 14th April 1948. It is a legal agreement between the countries whose overall purpose was to promote international trade by reducing or eliminating trade barriers such as tariffs. The GATT was first discussed during the United Nations Conference on Trade and Employment and was the outcome of the failure of negotiating governments to create the International Trade Organization. According to its preamble, its purpose was to substantial reduction of tariffs and other trade barriers and the elimination of preferences on a reciprocal and mutually advantageous basis. The GATT 1948 remained in effect as such until the signature by 123 nations, including India, on 14th April 1994. This signature of 123 nations on GATT established the World Trade Organization, which you know, WTO, on 1st January 1995. The next one, the WTO, as I have already discussed in previous slide, the signature of 123 nations, including India, on GATT established the World Trade Organization WTO on 1st January 1995. The WTO is the successor of the GATT, with its headquarters in Geneva, Switzerland, is responsible for administration and enforcement of provisions of GATT. Now see the TRIPS, trade related intellectual property system, is a part of GATT, which is the most comprehensive multilateral agreement on IPR and became effective from January 1995 itself. Uh, India is a member of the World Trade Organization WTO, became signatory into the TRIPS, which provides under Article 27.3b that the plant varieties are to be protected either by patents or by an effective sui generis system drawing its essence from UPAO. So now you can see that whatever varieties, they are all have to be protected with the patents or by any other system generated by the member countries. Based on the essence of UPAO, the Protection of Plant Varieties and Farmers' Rights Act 2001, PPV and FR Act 2001, was enacted in October 2001, and PPV and FR rules were notified in 2003 in our country, as UPAO had given the provision for sui generis system. So accordingly, India has made this. So consequently, the PPV and FR authority was established on 11th November 2005 by the central government via Gazette Notification number SO 1589 E with the following objectives. With the objectives to provide an effective system for protection of plant varieties, to provide the rights of farmers and plant breeders, to stimulate investment for research and development and develop new varieties, to facilitate the growth of seed industry, to ensure availability of high quality seeds or planting materials. Now see the PPV and FR implementation. the beginning of the implementation of an act which is a meticulous mix of scientific and legal aspects was a difficult task. The implementation required national level discussion and consensus on various issues. The proper planning, timely completion of tasks, and result oriented policies of the PPV and FR authority led to notable achievements in the short period of time. So, with the issuance of registration certificate to two new varieties and three farmers varieties in December 2009, the PPV and FRA made a remarkable beginning in the history of the intellectual property protection in India. So for registration, if you see the section 29.2 of the Act provides that the central government shall by notification in the official gazettes specify the genera and species for the purpose of registration of varieties. Now central government is notifying majority of the crop species for the purpose of registration. PPB and FR authority has developed guidelines for the conduct of species specific distinctness, uniformity and stability tests, which you call dust test, are a specific guideline for crop species. Now we should see the definitions related to registration. What do you mean by variety? What do you mean by farmers, etc. So if you see as per this PPB and FRA, what is variety? Variety means a plant grouping except microorganism. Means whatever the genotypes are grouped in different genotypes, all the germplasms grouped in different genotypes. We are not talking about the microorganisms. So all the plant genotypes in one group, in another group, they are the different varieties. What is farmer? What do you mean by farmers? As per the Act, farmer means any person who cultivates crop by cultivating the land himself or cultivates crop by directly supervising the cultivation or land through any other person or conserves and preserves separately or jointly with any other person any wild species or traditional varieties or adds value to such wild species or traditional varieties through selection and identification of their useful properties. Farmer's variety means a variety which has been traditionally cultivated and evolved by the farmers in their fields, or is a wild relative or land race or a variety about which the farmers possess the common knowledge. Now you see what is cultivar? A variety of plant that has originated and persisted under cultivation or was especially bred for the purpose of cultivation can be said as cultivar. What is a fork variety? Means a cultivated variety of plant that was developed, grown, and exchanged informally among farmers. What do you mean by land race? It is a primitive cultivar that was grown by ancient farmers and their successors. What is extant variety? Whatever variety is available in the country, which was notified under Section 5 of the Seed Act 1966. R is the farmer's variety, or a variety about which there is common knowledge, or any other variety which is in public domain can be considered under extant variety. Now, what is EDV? Essentially derived variety. In respect of a variety, the initial variety shall be said to be EDV. From such initial variety, when it is predominantly derived from such initial variety, or from a variety that itself is predominantly derived from such initial variety, while retaining the expression of the essential characteristics that results from the genotype or combination of genotypes of such initial variety, is clearly distinguishable from initial variety and confirms, except for the difference which results from the act of derivation, means crosses and development, to such initial variety in the expression of the essential characteristics that result from the genotype or combination of genotypes of such initial variety. Now see variety of common knowledge. If a variety which is not released and notified but is well documented through publications and is capable of satisfying the definition of variety as per the authority, as per the Act PPVFR, so that can be said as a variety of common knowledge. Once some documentation has been done, even it is not released or notified, that can be considered as a variety of common knowledge. The candidate variety should either have an entry in any official register of varieties, anywhere it is documented in the course of being made, or the candidate variety should find inclusion in a reference collection, or is having a precision description in a publication, or by any other means a variety has become a matter of common knowledge, that can be said to be variety of common knowledge. Now see the essential characteristics, means such heritable traits of a plant variety which are determined by the expression of one or more genes of other heritable determinants that contribute to the principal features, performance, or value of the plant variety. Now we can have an idea of fee related to registration process. The exact present price must be checked before going for registration. For conducting the test, the amount for dust test up to 50,000 per entry, depending upon crop, location, etc. When has to be deposited the fee? Once the application is accepted for dust testing. Then for registration of essentially derived variety, the individual 5,000, educational 7,000, commercial 10,000 at the time of submission of application. Then for registration of extant variety notified under section 5 of Seeds Act 1966, 1,000 rupees at the time of submission of application. For registration of any variety of the genera and species other than extant varieties and farmers varieties as specified in clause A of section 14 read with subsection 2 of section 29 of the Act. Example, new variety, the individual 5,000, educational 7,000, commercial 10,000 at the time of submission of application. For registration of extant variety about which there is common knowledge, that is the extant variety as specified in clause J3 of section 2 of the Act. Individual 2,000, educational 3,000, commercial 5,000 at the time of submission of application. Farmers variety, there is no fee for registration. Now see the duration of registration of varieties whichever you have registered as per PPVNFR. 18 years for trees and vines, whereas 15 years for other crops from the date of registration it will be valid. The registration will be valid for this duration. Certificate of registration will be reviewed and renewed after 6 years of annual crops and 9 years for trees and vines on payment of prescribed fee. Means it is valid for 15 years or 18 years, but it will be reviewed in 6 years and 9 years. For extant varieties notified under Seed Act 1966, 15 years from date of notification of that variety by the central government under section 5 of the Seed Act 1966. Here you have to clear it properly. The effective date will not be the date of registration. The effective date will be the date of notification of the variety. For other extant varieties, 15 years from the date of registration of the variety. The varieties which have not been notified as per Seed Act and they are extant varieties, for those it will be 15 years from the date of the registration in the PPVNFR. So there will be annual fee also, which is the annual fee shall be determined on the basis of declaration given by the registered breeder or agent or licensee regarding the sale value of the seeds of the variety registered under the Act during the previous year, and royalty, if any, received during the previous year from the sale proceed of seeds of the registered variety, and it will be verified by the authority. Then it will be decided the actual fee, annual fee for that registered variety. So what is the annual fee? The exact annual fee should be checked properly at the time of registration itself. So for new variety, rupees 2,000 plus 0.2% of the sales of the seeds of the registered variety during the previous year plus 1% of royalty, if any, received during the previous year from the sale proceed of the seeds of a registered variety. For extant variety notified, which has been notified under Seed Act, rupees 2000 only, no other percentage. The extant variety other than the category specified above, 2000 plus 0.1% of the sales of the seeds of the registered variety during the previous year, plus 0.5% of royalty, if any, received during the previous year from the sale proceed of the seeds of a registered variety. Now see the steps for registration. You have to apply first. The application by the breeder or farmer along with the registration fees. Internal scrutiny will be there. Then application can be accepted or rejected. Then seed deposit, the National Gene Bank plus dust test fee. Seed you have to deposit in the National Gene Bank and you will be getting a number from the National Gene Bank. Uh, then also you have, as dust test has to be done, you have to deposit the fee for dust test. Then publication of minimum passport data in Plant Variety Journal of India. It has to be published based upon the dust test, the minimum passport data of that variety. Dust test for at least 2 similar crop seasons will be done. Then analysis of data. On that basis, it can be accepted, the dust or rejected as per the passport data. Then entry in National Plant Variety Register. Then registration certificate granted. Then it will be published in Plant Variety Journal of India for submission of claims for benefit sharing. Now see the benefit sharing, compensation and rights provided under the Act. Benefit sharing, Section 26 deals with the benefit sharing. The claims under benefit sharing can be submitted by citizen of India or firms or NGO formed or established in India. Such claims, after due examination and after receiving counter claims with the will be disposed by the authority. Whatever claim has been made by citizen or NGO or anybody established in India, that will be disposed after proper examination by the authority. The amount thus determined shall be deposited by the breeder, whatever claim has been made by the individual, in the manner referred to in clause A of subsection 1 of section 45 in the National Gene Fund. Rights of communities in relation to compensation. Section 41 provides for settlement of any claim attributable to the contribution of the people of that village or local community in the evolution of any variety registered under this Act. Compensation to be determined by PPV and FRA and deposited in the gene bank. Now see the rights of farmers. Under section 39 of the PPV and FR Act 2001, farmers' rights have been given. A new variety bred or developed by farmer will be registered in like manner as a breeder of a variety. Farmer engaged in conserving of genetic resources of land races, and while relatives of economic plants, improvement through selection and preservation shall be entitled for recognition and reward from gene fund, provided that the said material has been used as donors of genes in varieties registered under this act. Farmers can save, use, sow, reshow, exchange, share, or sell farm produce, including seeds of a protected variety, but cannot sell branded seed of a variety protected under this act. This has to be kept in mind because of the law. A lot of hue and cry in those days. The sui generis system was made, was accepted for all member countries. Accordingly, this provision was given to India also, that our farmers can save their own seed for its use and reuse, for sowing, resowing, for its even exchange, share, or they can sell also the farm produce as a seed of even protected variety, but cannot sell seeds as a branded seed. So this is about the rights of farmers. See that breeder shall disclose expected performance of the protected variety under given condition, that in this environment, in this area, in this state, his variety will give this much average yield or any other quality traits in given condition, and farmers can claim compensation if variety fails to meet those expected performance. So section 42 refers to protection against innocent infringement violation. Section 43 refers to authorization required for EDV developed from farmers variety. Section 44 provides that farmers are exempted for payment of any fee for any proceeding or application or for even dust test. Now see the breeder's rights. Breeders shall be required to deposit seeds or propagating material, including parental line seeds of registered varieties, in the National Gene Bank as per section 27. A certificate of registration for a variety issued under this act shall confer an exclusive right on the breeder or his successor, his agent or licensee, to produce, sell, market, distribute, import, or export the variety as per section 28(1). Breeder can appoint agent, licensee, and can opt for civil remedy in case of infringement of his rights, provided that the authorization of the breeder of the registered variety is required where the repeated use of such variety as a parental line is necessary for commercial production of such other newly developed variety. Particularly if you see in hybrids, every year you need both the parental lines for producing the hybrid seeds. Now see the compulsory licensing as per section 47. After the expiry of 3 years of issue of certificate of registration, any person can appeal on ground of inadequate seed supply. If you have registered it, and after expiry of 3 years, if you are unable to supply the seed of that registered variety, or maybe not reasonable price you are selling, from the breeder to undertake production, distribution and sale of seed, authority will hear both the parties and in public interest may order breeder to grant a license to the applicant on a payment of a fee. Period of compulsory license will be maximum up to period of protection only. That cannot be extended. Maybe if it is for 15 years and after 3 years it has been made claims, so only 12 years will be there for protection of that variety under this act. So authority can settle terms and conditions, revoke or modify compulsory license. Now see the infringements. Under section 64 of the PPBFR Act, a right established under this act is infringed by a person who, not being the breeder of a variety registered under this act, or a registered agent or a registered licensee of that variety, sells, exports, imports or produce such variety without the permission of its breeder, or within the scope of a registered license or registered agency without permission of the registered licensee or registered agent, as the case may be, who use, sells, exports, imports or produce any other variety, giving such variety the denomination identical with or deceptively similar to the denomination of a variety registered under this act in such manner as to cause confusion in the mind of general public or people in identifying such variety so registered, they all are coming under infringements. Further, section 65 of the act provides that the suit for the infringement of a variety registered under this act or relating to any rights in a variety registered under this act should not be instituted in any court inferior to a district court having jurisdiction to try the suit, where district court having jurisdiction shall mean the district court within the local limits of whose jurisdiction the cause of action arises. Thus, the cases of the infringements are not supposed to be dealt by the PPV and FR authority until or unless referred to by the concerned courts for any scientific opinion. The following are the suggested readings: www.plantauthority.gov.in. Bala Ravi S. 2006. The conflict between Biological Diversity Act and PPBFR Act in Excess of Benefit Sharing. Current Science Volume 90, number 1, page number 815 to 819. Chandrasekharan S. and Vasudev S. 2002. The Indian Plant Variety Protection Act. Beneficiaries: the Indian farmer or the corporate seed company Journal of Intellectual Property Rights, Volume 7, page 506 to 515. Singh Praveen Kumar, 2011, Implementation of Protection of Plant Varieties and Farmers' Rights Act 2001, Indian Journal of Genetics, 71, Volume 2, Special Issue, page number 190 to 198. These are the suggestions for further read all about PPB and FRA 2001. Thanking you very much.